Okay, so what are the steps to trial? So after all the preliminary stuff, all the filings and motion, et cetera, get started, in a civil trial, it begins generally by a party's opening statement. Both sides can give their opening statement up front, or the defendant or their counsel can defer and give their opening statement later. But it begins with the opening statement by the plaintiff. So plaintiff gives the opening statement. If the defense counsel defers, then the plaintiff puts on their case, their demonstration of evidence supporting the cause of action. At the end of the plaintiff's case, the plaintiff rests. At that point, the defendant will ask the court to dismiss the case based just on the presentation of evidence. The court will review the evidence as presented and say, is there a minimum amount of evidence where legally a jury could potentially find that all of the elements of the causes of actions are met? If not, the judge can dismiss the case as a matter of law. If there's a minimum, basically the standard is any evidence presented towards every element of the causes of action, then the court will allow it to proceed. And then the defense presents their defense of the case. And they will tend to assert any claims, evidence, etc., that somehow offers a justification or disproves the facts that the plaintiff presented. At the close of the defendant's case, the plaintiff side may have a chance at rebuttal and then serve rebuttal again by the defense. And that depends on jurisdiction as to the amount of time and amount of that is allowed. The bottom line, the plaintiff and the defendant have the ability to present their entire cases. After that, the jury is given the state of the law, given the jury charge, as they call it, and then they deliberate, and then they come back with a verdict of liable, not liable, okay? Whatever they come back with, they may also be charged with, and it may be in a separate demonstration by the parties as to the amount of damages to be awarded, okay? And the jury in the court will hear evidence as to damages suffered, and then the jury will go back and determine damages. The jury makes the recommendation for damages, which the judge affirms and enters in as a judgment. And from there, the parties have the option of, generally the losing party will reserve the right to appeal the case within a statutory amount of time.